And I'll be presenting today's cases in review for today's public hearing. Would ask you at this time, if you would please, if you've got your cell phone with you, if you'll put that phone on silent or turn it off, that board would appreciate that so as not to interrupt today's proceedings. The process today will be, I will go through the case record as the Codes Department has it, and I'll do that on the walls here by means of a PowerPoint presentation. I'll present the case as submitted by the applicant, and after I'm done with my portion, the applicants will come first to the table to my right, pull the microphone up in front of you, identify yourself with your name and address, and then make your presentation. In cases without opposition today, you'll have 5 minutes to present your case, applicants. And that clock will be just up on the wall there, just to the right of where you'll be seated facing the board. And in cases with opposition, you'll have 10 minutes per side of a case to present a testimony. As we talked about prior to the meeting here with the audience, that 10 minutes is per group or per side of a case, not per speaker. So if there are multiple speakers, please work out your timing accordingly. The clock will run on testimony and will stop for any questions or answers that the board might have for you or your answers to those questions. But once you've completed your answer, we'll start the clock back up. Ladies and gentlemen, I'll go through all cases set for public hearing today, and after the board hears the case, they'll discuss and vote on the case in front of you. The board's empowered to act with the cases before us under Section 1740-180 of the Metro Code of Law. The code requires that 4 members of this 7-member board be present to constitute a quorum. I've got 5 currently present. I am expecting a 6th here just shortly. But with 5, we will proceed and begin today's agenda. To have an approval today, you have to have 4 of the persons present vote in favor of your case to be approved. Failure to have 4 affirmative votes on your side as an applicant, your case will stay on the agenda for the next 30 days. So the board will have 1 hearing in the next 30 days, 2 hearings in the next 30 days. So your case will stay on the agenda for the next 2 meetings. The members that participated are allowed to change their vote. The members who were not present are allowed to review the testimony of today's hearings. Our meetings are recorded on YouTube, on Metro 3's YouTube channel. They'll watch the proceedings, they'll look over the case file, and then they are eligible should they wish to participate in the next case. If you fail to get that 4th vote by the time 30 days elapses, your case will be deemed denied by operation of law. The board is empowered by the state of Tennessee to hear cases under Section 13.7.207 of the Tennessee Code. Ladies and gentlemen, I'll go through the cases first today on our agenda, and I'll first go through cases that have been withdrawn. And so if you are here in any cases been withdrawn that I'll call, you are free to depart because that case will not be heard by the board. The first case on our agenda withdrawn is case 2024-23. This is on page 3, XE Development Company at 2708 Tucker Road. They were requesting a variance in the landscape buffer requirements. That case has been withdrawn by the applicant. Case 2024-24. This was a request regarding the Islamic Center of Nashville and the reasonable accommodation granted by me to the Islamic Center for an LED sign. 2 applicants filed an appeal with the board within the 30-day period as required by law. The applicants failed to notice the adjoining property owners as required by law, and that case is withdrawn. That particular case is now completed. The 30 days has elapsed and no further appeal will be taken. The permit for the sign will be issued by the Codes Department. The next case withdrawn is case 2024-26. That will be at the top of page 4. That's Jeremy Payton at 5701A Maudina Avenue. That case has been withdrawn. And finally, the last case withdrawn, which may have been advertised, 2024-32, the Farm Nashville LLC It is a request for a special exception regarding a golf course that this board previously approved on Night Drive in the 34, 36, and 3700 blocks of Night Drive. That case has been withdrawn by the applicants. So again, if you are here for any of the cases that I'm going to call again, that is case 23 on Tucker Road, case 24 on 12th Avenue South, case 26 on Modena Avenue, and case 32 on Night Drive. Those cases were withdrawn. If you're here on those, you are free to go. Mr. Chairman, the next group of cases are cases that have been deferred by applicants or the board. The following cases that I'll call today, and I'll give you the dates of that deferral. The first case is on the top of page 2. This is Jolo Enterprises on 2629 Gallatin Pike. They were requesting a variance in the frontage requirements in the MULA district. This was to construct a drive-through restaurant, I believe, for Whataburger. The applicant has requested a deferral, and this board is granted until April the 4th, 2024. That meeting will be held in our usual location at 800 President Ronald Reagan Drive in the Howard Office Complex, where we meet in the Sunny West Auditorium. That's where that case will be held. And that's case 14 on for the Whataburger on Gallatin Pike. The second case, which has been deferred to that same agenda, is case 18 at the bottom of page 2, Roberto Gutierrez, 2419 Brick Church Pike. That case has been deferred to April 4th, 2024 as well. Third case deferred by the applicants is case 2024-25. That's Mainland West End Circle. At 3207 West End Circle, they were requesting a variance from the maximum parking requirements. That case has been deferred to April the 4th, again at the Sunny West Conference Center, 800.
Mr. Harden,
Ronald
I
Wilson.
think that may be there. We're here today and did not, I don't think SECA is booked in today's docket. Apologies for any inconvenience.
Okay, I will let me check my notes, and if
Yes, sir.
that bears out, Mr. Michael, we will actually hear that case here. So. The next case deferred by appellants is case 2024-27, Mr. Roberto Gutierrez, 2415 Brick Church Pike, requesting a special exception for street setback and height. Again, that case will be deferred till April the 4th, 2024. Again, at the Sunny West Conference Center at Howard Schools. I think that is the last case. Mr. Chairman, I'll get the case Mr. Michael raised for his client. I think that the issue at the time with that particular case, my notes here was that the public hearing sign was not up. I think I understand that staff went to the wrong location. If my memory serves, and I think Mr. Michael's correct, I'll open that PowerPoint back up and we'll hear it in its regular order. That case was not recommended for the consent agenda, so we would hear it in its usual order. So again, if you were here for deferred cases 14 for the Whataburger on Gallatin Pike, case 18 on Brick Church Pike, case 27 also on Brick Church Pike, you are free to go. Those cases will be heard on April the 4th, 2024, in its usual location at Sunny West Conference Center. Hey, Mr. Chairman, before we get to consent agenda, the board does allow elected officials to address the board on particular cases before them. Are there any elected council members present who would wish to speak at this time? All right, council member, you're allowed, if you'd like to, without a time limit. You can come up and speak now, or you can wait till the case comes in its order. It's your choice either way. But we're happy to have you.
An extra copy of the agenda.
Yes, ma'am. You're welcome to have mine.
Let's do it. Good afternoon. I'm Joy Kimbrough, councilperson for District 1, and I will address you on case number 2024-017. This is my first time appearing for this body. I am here today because of the overwhelming I guess I would say, I don't want to say rejection or, overwhelming feelings about the Zeal Church coming to the Cato Road, Ashland City area. I have received numerous emails, and I'm sure you have, because some I'm cognizant. So I am here today on behalf of my community to let you know that they are vehemently opposed to this church coming to the area. And if they're opposed, I too am opposed. So I want to make my position clear. We are opposed to the Zeal Church being relocated in that area. I don't know if you have visited that area, but it's not an area that would be welcoming or be able to accommodate a church or anything else such as this. Just recently, Cumberland Elementary, which is right over there on Cato Road, had a book fair. I was there, the mayor was there, several council members were there, school board members were there, and they were able to see. These people, several of them commented to me afterward, I don't know how you all get in and out of Cato Road. I don't know how you do it. Did you request a light for the capital improvements budget? It's just so bad, the traffic and the back up there. And I do believe if this went forward, it would present several issues. First and foremost, safety issues. Safety, just going in and out from Cato Road to Ashland City Pike. And because the way this is uniquely the uniqueness of the area or the design, you almost have to see it. Cato Road is a very narrow road. Another place that the Zeal Church is suggesting entrance is you have to go up a little ramp where there are about 3 or 4 houses. And I don't even think there's a dividing line there for the traffic that would come. But that's another way, my understanding is they suggest to enter. It'd be on Ashland City, and you go up this little ramp, and you pass these 3 houses on the right, one way in, one way out. And you would go from there. So it's just as it is, and it's nothing personal against a church, but I've seen the problems they have on Charlotte, which is far more able to accommodate them than our community is. So I am here today to say we are opposed. I've held a meeting. Everybody was opposed, other than the church itself. But every community member, and this was well attended, it was well publicized, they were all against it. And I came today because one thing I want for our community is change. I want our voices to be heard, and we don't want to be the community that everybody just decides we'll do what we want over there. We have suffered, and I know this isn't your problem and you didn't do it, but we've had a dump for years. Then they relocate dumps. And now they're going up Ashland City Highway and dumping, and people are paying them, they're paying residents there to dump in their yard, and that's something I'm about to deal with now. We just can't support the church at that location at this time. And I just wanted to make sure that it's perfectly clear. Not only is my community against it, I am against it. Thank you.
Ladies and gentlemen, I asked if you're here with other folks and you've got multiple copies of the agenda, can you raise your hand? Let me get a couple back from some folks if you don't mind. Okay. Anyone else? Raise your hand. Thank you. Sorry to get taken care of. Okay. Thanks, bud. I apologize. Crowd was a little larger than I expected in my print job. So, okay. Well, the last procedural item before we begin today's case will be to go over our consent agenda. The cases that I'll call now are cases recommended by the chairman to the rest of the board for consent. Consent means approval by this board, and if there are no parties in opposition to the cases that I'll call now, and you are here in opposition, please, I'm going to turn and face you. If you'll raise your hand, let me be sure I acknowledge you. If there is opposition present, we will hear the case back in its regular order. I'll call now the cases recommended for consent. And again, if you're here in opposition, please raise your hand. The first case recommended by the chair for consent is case 2023-155. It's on the front page of our docket. Mr. Alan Smith on Skyline Development LLC, the owner of the property, seeking a special exception in the CS district to construct a new two-family, single-family homes. Are there any parties present opposed to case 155 on Old Hickory Boulevard? Mr. Chairman, let the record reflect there are none. The next case recommended for consent is case 2024-29. It'll be at the bottom of page 4. Mr. Brett Diaz, the appellant owner of the property at 2212 11th Avenue South, requesting a variance in the rear setback to construct an in-ground swimming pool. Are there any parties present opposed to case 29? Chairman, the record reflects there are none. The next case recommended for consent, case 2024-31, Kate and Devin Malone, appellants and owners of the property located at 330 Gatewood Avenue, also known as 1433 Pennock Avenue, requesting a variance in the street setback requirements. Are there any parties present in opposition to case 31? And Mr. Chairman, seeing none. And the final cases recommended for consent are cases 2024-33, PR3, Wood East Nashville LLC, the appellant and owners of the property located at 900 East Trinity, requesting a variance in the setback requirements for construction of a wall sign. Are any parties present opposed to case 33? Mr. Chairman, I see none. And finally, case 2024-34, St. John's Chrysostom Romanian Orthodox Church, and Pastor, please forgive me if I mispronounce that, for a new special exception for the construction for an addition at the church at 4112 Union Street. Are there any parties here opposed to the case on Union Street? Mr. Chairman, seeing none, let the record reflect that is your consent agenda. Is there a motion?
Make a motion to approve.
Second.
Okay. Mr. Bowles, second.
Second. Okay, sorry.
Okay, if you're here again, just recapping cases 155, 29, 31, 33, and 34, your cases have been approved. It is necessary for you to check back with the codes department beginning Monday to follow up of whatever's left to be done on your building permit. So you guys are free to go. Mr. Chairman, that leaves us with the following cases to be heard in this order. The first case that will be heard will be case 2024-17, Barge Cawthon Associates for the church on Cato Road. The next case that will be heard after that will be case 2024-25 on West End Circle. And then final case to be heard today will be 2024-30 at 140 Hillside Cottage Lane. Those will be the sequence of events. Mr. Chairman, there has been a request made by the opposition in case 17 for additional time. So I bring to you, I believe that if the board is willing to grant them more time beyond the 10 minutes, let you guys make the decision on how much time to grant them. A requisite amount of time will be awarded to the applicant as well.
If you're here to speak in opposition to that application, can you raise your hand so we can kind of see how many?
I'm going to be back in just a minute. Okay.
Okay. All right. So, and obviously, if we give the opposition additional time beyond 10 minutes to speak, we would give that to the applicant too. I'm fine with granting some additional time. There was a lot of people took a lot of time to send in comments about this, and there's a pretty good number of people here. So I think 15 minutes apiece or 20 minutes apiece, whatever. 15. Yeah, okay. We have read a lot, so we're definitely up to speed on it. So I'll make a motion that we allow each side in that case 15 minutes to speak. Is there a second? Second. Okay, all in favor? Okay.
Okay, ladies and gentlemen, the board is voted on case 17 to grant 15 minutes. Again, that 15 minutes will be allotted to both sides. I'll change this clock to reflect 15. This is our first case that we're going to go into. So first and foremost, I'll go through and welcome everybody to the Board of Zoning Appeals. I'll present our case record that we have it first, and then I'll turn it over to the opposition. To the appellant, as well as any parties in support of a case. For 15 minutes. Appellants, you will want to save a portion of your 15 minutes for rebuttal. That can be the remainder of what's left after you speak. You could reserve some on the front end. That's totally up to you, but we'll save that amount should you want it. Opposition, you do not get a rebuttal. Your 15 minutes, so all the parties that wish to speak today, you've got 15 minutes to divide amongst yourselves. So go ahead and have those discussions as quietly as possible. If you need to step out to divide your time, do so. But when you come up, go ahead and load all 4 chairs, and we'll just go through. Again, the clock will be to your right. The clock will stop for questions and answers. We'll resume once testimony begins. But first will be for me to put the presentation together. So again, the case is 2024-17. The subject parcels involved are actually several parcels here. It's the parcel to the red as well as the parcel north where the property that shows it there with the red text. Those 2 parcels involved. This is an aerial photograph taken in early 2022, I believe, are our latest aerial photographs of the subject area. And you see the elementary school located here. This is a view of the subject site upon our staff members' visit to the site. This is a view along Ashland City Highway where the on-ramp goes on to Briley Parkway. And I want to originally show the Metro GIS maps listed this drive here that leads back into the subject site, if you can see where my cursor is moving, as Ashland City Highway on our maps. Even though, as you can see, Ashland City Highway is immediately to the south. This is more of kind of a feeder road to it, but our official maps do list that also as Ashland City Highway. So if the question comes about our addresses, that's why it shows that little drive that you see that serves those 3 homes leads back into the subject site. The proposal, as you'll see on the site plans coming, shows access off of Cato Road. And views towards site, views along Ashland City Highway. This was that feeder road I discussed earlier. It's an elevated off and separated by the barricade from Ashland City, and a view along that area. And a view from Ashland City up into the subject site, facing northwest. This is the home that currently sits at 4309 Cato Road. And then a view along Cato Road. This is facing south toward Ashland City Highway. You notice in this photograph the school zone sign, the elementary school located immediately to the south of the property. And then a view along Cato. This is the parcel information from Metro GIS, and in discussion with the fire marshal, there could be a capacity based on the proposed size of under the zoning regulations say that based on the size of this parcel for new religious facilities that the maximum amount of people could be 3,278. I don't believe that's what the applicant's proposing, but that is what the zoning code would permit based upon the size of the acreage of the 2 parcels. Again, a note here that the fire marshal will ultimately set the capacity for the building that's there. Again, we talked about that discussion, that portion that's listed as Ashland City Highway. This is the zoning code as it relates to new religious facilities, and I won't read all this, and you have copies of this but the minimum acreage requires 5/1000 of an acre for every seat. Again, this consists currently of 2 parcels. They are well in excess of that. For collectors, for variances on for churches of the size, they're required to be on a collector street. Cato Road is not a collector, not an arterial street because of the proposal of the church to exceed more than 1,000 seats. The BZA is authorized to waive that street standard based on a favorable traffic recommendation from a Metro traffic engineer, and to be generated, that the traffic amount of volume to be generated by the facility can safely and efficiently be accommodated based on the existing local network without adversely impacting the surrounding neighborhoods. That's something you all will need to judge in your landscape buffers are required along all structures and property lines. The site plan shows reflection of this. Churches are also, I say churches, religious institutions are also allowed to have on-site cemeteries. That's not being proposed here. Again, talking about the street standards for religious streets. Note here, the NDOT finds the proposal does not meet the requirement of being located on an arterial street, and no waiver recommendations were provided by the Metro traffic engineer to this board. This is the, let me back up. This is the site plan that we had. Scan into it. I'll look. I think I've got another one as well, and I'll pull up while the appellants are coming forward in our case file record. Members of the board, I'm gonna leave the slide itself here to assist you, to give some time there. Again, the board has granted applicants 15 minutes to present their testimony. If the applicants want to come forward at this time, have a seat at these chairs in front of you, identify yourself, and make your presentation to the board. Board members, for your mics as well, I've got them all turned on, but if you don't see a green light at the very bottom of your microphone, go ahead and hit that when you speak. Mr. Michael, yours is on. I think, sir, yours will now be on. And I'm going to mute mine so we don't get feedback. And with that, I'll turn it over to.
Thank you, Mr. Hargis. Mr. Chairman, members of the board, my name is John Michael with the Thompson Burton Law Firm here in Nashville, 1801 West End Avenue. I'm joined by representatives from Barge Carlton and from the Zeal Church, and we'll make a presentation today requesting a special exception under the Metro Zoning Code provisions under 1716. As you know, religious institutions in residentially zoned property, a situation like this one, require the special exception. Fortunately, with the legal standard in place, it's formulaic in the sense that you have three specific conditions, as Mr. Hargis just outlined them. One involving lot size. Clearly, we more than meet that condition as laid out in the memorandum I've submitted, dated February 28th of this year, as well as in Mr. Hargis's comments. Secondly, there's a landscape buffer condition that happens at the permitting time. If we get to that point, we'll be required to put in a landscape buffer for portions of the property that neighbor residentially zoned and residentially used properties. No problem. We're delighted to do that. The third component, which we also meet, is a requirement that the property have at least one frontage on an arterial street. That's a question that's been presented, and therefore we want to emphasize a little bit more today. In an abundance of caution, we have amended our application and renoticed this case to include a variance request also, so that in the event the board doesn't find our argument sufficiently persuasive that Ashland City Highway is the arterial that connects this property. We have also requested the variance to demonstrate the hardship associated with the taking that took place once the on-ramp from Ashland City Highway, also known as Tennessee Highway 12, up to Briley Parkway many years ago. This was a nearly 3-acre taking from the property owner, Ms. Gladys Bond, who's owned this property for many, many years, to develop that. Therefore, the hardship associated with the taking is what removed the opportunity for a direct driveway that touches 4460 Ashland City Highway, her property, directly onto Ashland City Highway. And that's why you see the address for this property as it is, with an ACH address. The 3 residential lots to the immediate east or the right in this picture also share the shared private drive down to Ashland City Highway, but all 3 of those properties, which I believe are 4458, 4454, and 4448, Ashland City Highway, because they too had the direct access. If you look then to the 4th house to the right, not sharing that private drive, you'll notice they have a direct driveway that touches Ashland City Highway. This is the frontage that our property at 4460 would touch, but for the right-of-way that was taken by the state of Tennessee, and of course compensated. I don't mean to suggest otherwise. It was an eminent domain case. But also bringing them straight down to Ashland City Highway before then, now using the private drive. An important note clarifying one item in terms of an initial staff level engineer who had given the response with regard to NDOT's determination that this did not have an arterial frontage as required by the language of the special exception. In a follow-up to the staff member at NDOT, Sarah Kane, who staff will recognize as being the person who manages the Metro GIS map for NDOT, particularly for emergency coordination with fire and EMS, in an email response to two questions. One, is this drive just above Ashland City driveway, a city street, or a private drive? And two, do you have any indication as to which entity maintains that area? Ms. Kane's email dated February 27, 2004 at 3:27 p.m. reads, this is quite the popular question, the section you are referring to is a private drive, and it is noted on the GIS center line that it is, quote, maintained by TDOT per Joe Payne, 7/20/04. Joe Payne worked at TDOT, period, end of quotation. The note there shows us that's a shared driveway per NDOT and the individual who is in charge of the mapping for these questions at NDOT. TDOT maintains the right-of-way in that area. It basically cuts the grass is the shortest version of that. But for this drive, but for the ramp that leads you up to Briley Parkway, 4460 did and would again touch Ashland City Highway. We contend that the private drive is not a city street such that 4460 is not just touching a local road like Cato Road or many of the other residential roads around us. Instead, the appropriate access point is Ashland City Highway, as seen by the private drive that empties out onto Ashland City Highway just to the right or east of the beginning of the ramp there. To that end, we are not failing to acknowledge the other two conditions. Again, landscape buffers typically are covered just at the permitting stage. We look forward to complying with that requirement. The lot size is more than adequate for an auditorium that we think over two phases will total 1,200 seats, not the 3,000 plus that would otherwise be permitted by law for a lot of this size once combining the two lots, one facing Cato, one facing Ashland City Highway. We believe that we're identifying that with the addresses on Ashland City Highway, with all four of the properties on that private drive also having connections to Ashland City Highway and similar addresses, Ms. Kane's email from the National Department of Transportation confirming that that is a private drive, not a city street, and that all of this stemming from the right-of-way taking by the state many years ago, that number one, we've demonstrated that this is connecting to an arterial, which is the best way to circulate in and out traffic on that road. Forgive me, Mr. Hargis, I don't recall if you had a street photo that showed the little private drive itself. For years, this has basically served the three houses there, and this is the drive that we're talking about. As you can see, it meets more than the 24-foot minimum width required by NDOT for a regular two-lane drive of a commercial type, but is nevertheless a small private drive, not striped, no sidewalk, curb and gutter, grass strip kind of stuff. It's just a private drive and has been ever since it was put in place after the state took the land from Ms. Bond for that right-of-way incursion. Yes, the Religious Freedom Restoration Act under state law applies. Yes, the Religious Land Use and Institutionalized Persons Act under federal law applies here, but we want to emphasize that we meet the zoning code requirement for the special exception first. If for some reason the majority of the board does not determine that we have met that, we point to the hardship created by the state's eminent domain taking that clearly, as you can see from the aerial on parcel view, took away the original connection to Ashland City Highway. That hardship is the only reason that property still doesn't touch Ashland City Highway, the same it did many, many years ago. So with that in mind, as a belt and suspenders approach to the argument, we wanted to point out that one, we believe we meet all three conditions of the special exception. Two, failing that, we ask for your consideration of a variance rooted in the hardship that we've outlined here today. And the only third part, although having touched on referenda RLUIPA, that I'll come back to is a reminder of what the case is not. It's not a question of whether or not a church is the appropriate land use at this property. That's not what the board is asked to decide today. It's not a question of the church building size. The auditorium is much smaller than would otherwise be allowed. It's not a question of the days of operation, the denomination or faith, who goes to church there, what ministries they pursue. None of that is before the board. Only the question of the special exception and the land use of the church in a residentially zoned property. With those special exception conditions having been met, if the board determines that they have, then of course discretionary determinations are no longer part of the analysis, and instead it's just a rote matter of if yes, then approval based upon state law in Tennessee. With that, we will of course request your.
Can I ask you a question?
Yes, sir, of course.
So this is a special exception, and are you saying the Religious Institutions Act means that we can't, as we normally do, consider the adverse effect on neighboring properties? Or
the adverse effect is still part of the analysis, but the adverse effect is typically under the Religious Freedom Restoration Act, a question of health safety matters, and the ways that that has been challenged in the past with some success is if it's perhaps you're right next door to an industrial property that has toxic fumes or otherwise bad activities on the property that would make people unsafe to have as a gathering place. That's exceedingly rare, of course, and only found in other jurisdictions for the most part, but it has happened before. So laws like RLUIPA and in our state version, RFRA, are not completely immune from exceptions. They're just rarely found.
But so you're saying the standard is different because this is a religious institution?
It's a higher standard than if this were a matter of a special exception for some other land use, like a commercial business or a multifamily development of some sort that perhaps was allowed to travel with special exception permission from the board. A church enjoys more protections. Any religious institution enjoys more protections through the state law and the federal law than those other instances.
Does that foreclose us from considering the adverse effect on the neighbors?
I think not. Not under the legal standard. I would love to tell you that yes, it does, but it doesn't.
That could include traffic concerns as well as devaluation of the property.
That's a question that if the courts in Tennessee have decided that traffic, mere traffic, rises to the level of being a public safety harm, particularly on an arterial like Ashland City Highway, Tennessee Highway 12, I've not seen the case law that supports that.
Okay, well, thank you. I appreciate that.
Of course.
I didn't mean to interrupt you, but
No. It's, we understand there'll be
also
questions.
And if I may interject for a
Sure.
moment, just to clarify, I think as you were clarifying that the general provisions of 1716, 150 apply to
Do apply,
special
okay,
exceptions.
yep.
And there is a RLUIPA process, right, that under our ordinances, if you would like to apply under that, you apply to the zoning administrator, and if there's an appeal from his decision, that would come to this board. But I don't know if that process has been, my understanding just.
We've not pursued that.
Right, so we're not here under that framework right now, is the best of my understanding.
And though while the law is applicable, it is not the framework that we have pursued the reasonable accommodation under that ordinance. I say ordinance because it is the reasonable accommodation, the ordinance rooted in RFRA, the state law statute.
Mr. Michael, does that understand the health and safety component that you referenced here, just so I'm clear? This is the kind of circumstance where it would basically mean that, you couldn't rely on the Religious Land Use Practices Act to say, have a 75-to-1 student-teacher ratio for a daycare or something like that, right? That it wouldn't, it's intended to prevent, dangers to people and to health. Not that a church would necessarily be operating a manufacturing facility or something like that, but
Public safety,
Yeah.
that's the key concept there.
but you're saying that's the basis by which the board can sort of accept that statute.
I think that if I understand your question correctly,
It's a
think yes,
bad
that's
question,
correct.
so, but yeah, okay, thanks.
And Mr. Chairman, I also wanted to make sure you had an opportunity to hear briefly from the pastor from Zeal Church, as well as my colleagues from Barge Colvin, who are the engineers designing the project. They'll have an opportunity to give you a little bit more of an overview of the ministries that this church wants to be involved in the community as they hopefully get to expand to this location. And then Barge Colvin representatives, Mr. Hooper, will have the opportunity to explain a little bit about the project and design itself.
thank you.
Awesome. Thank you so much. Members of the board, thank you for your time. Leah and I, that's my wife, we started the church back in 2015 in West Nashville in our house, and it was healthy, and healthy things grow. And so we went from there to a public middle school, and that was awesome because we were able to add value back to the middle school and stayed there for several years. Then we've been on Charlotte Pike, and the organization has grown, and the church is healthy and serving and making a difference. And so for us, when we found this many acres, 5 minutes from where we currently do church, it was we felt like it was a great opportunity to begin to see what are the opportunities with this land. Is it possible and feasible? And so thank you so much for your consideration. We look forward to making as much impact as we can on the city. So once again, thank you so much. I appreciate it.
Thank you.
Good afternoon, Mr. Chairman and members of the board. My name is Jeff Hooper with Barge Civil Associates, 6606 Charlotte Pike. As Mr. Michael and Mr. Hargis has previously presented, I think the question today is about this little access road. The church has looked at different properties in the area actively, and unfortunately, those have not panned out to date, and we're hopeful that this one absolutely does. But with regard to that connection, it's clear that Ashland City Highway is an arterial boulevard. The shared driveway between 4460 Ashland City Highway, the appellate's property, and 4458, 4454, and 4448 Ashland City Highway provide the required arterial access required by the zoning code. The shared driveway was created by TDOT when it obtained right-of-way for Ashland City Highway and the Briley Parkway interchange. In fact, the warranty deed for the appellant's property identifies access to State Route 12, which is Ashland City Highway, by a driveway and access shown on the plans. By a driveway and access shown on the plans. If the private drive were a public street, the statement would not have been necessary. As Mr. Michael noted, we did talk to Ms. Sarah Kane with NDOT. The traffic engineer said we did not meet the standards for an arterial. Ms. Gaines noted that NDOT's official map and records, which is Metro-owned and maintained streets, which is passes councils every year, shows this access as private. That's further reinforced by Metro GIS parcel viewers you've seen, which also shows the access is private. The Alta land title survey performed for the intended real estate transaction also denotes the access is private. Lastly, the appellant's property, along with 4458 and 4454 and 4448, have an Ashland City Highway address as assigned by NDOT. If the private drive were a different public street, it would have a legal street address and would reflect accordingly for emergency and postal services. For these reasons, we believe an appellant's property directly discharges onto an arterial as required by the zoning ordinance. So we appreciate your consideration of that this afternoon, and we will reserve our remaining time for rebuttal.
A question.
Yeah, thank you.
Before you do,
Okay.
I can't get this to stop, so
okay.
I'm going to keep it on my phone and then get this weekend. So,
Okay.
you got 3.
And Madam Vice Chair, even before your question, we also wanted to note that Mr. Ben Jordan is also in attendance today. He is the real estate representative for the current property owner, Ms. Bond. In the event that any of the board members had any questions that might be appropriate for him, we wanted to let you know.
Okay, thank you. Is there an intention to do a traffic study?
Yes, actually, the zoning code will require it. The MMTA, multimodal transportation analysis, as they're called now, will have to be completed in part of the design and permitting process.
Okay, so at some point there will be a traffic study.
Correct.
And there,
And Ms. Kaepernick, the group has already engaged Ms. Ostrowski from KCI to work on that.
okay, sounds good. And then this small private road that we've been talking about, is there any intention to use that road or just Cato Road?
Both.
Both. Okay.
Yes. That is the primary arterial access as required by code is the shared driveway.
So then for the arterial road, what you're referring to as a private road will be the road that is used to connect to the church, is that correct?
It would be a private drive.
Connecting to the parking lot.
Correcting to the parcel like any other development in Nashville would.
One question I have on that private drive, looks like it's in a bit of a right of way. Who owns that drive?
The private drive is in TDOT's right of way, and they maintain the turf and everything else in that right of way.
Including the road. They maintain that road as well.
I would have to confirm with that. I would assume yes.
The only information we got from NDOT was that TDOT, the information from NDOT was that TDOT maintains the right-of-way, and that was a very broad statement. This pavement does not look like it's regularly repaved. It's never been striped that we can see from older aerial photographs. But nevertheless, it's clear that the grass is at least maintained, so they're on top of that.
Right, 'cause I guess I'm just confused when you say private drive, that's what makes me think it's not maintained, but, okay. Thank you. Address.
If there are no other questions, again, we'll hold the remainder for any
I'm
rebuttals.
sorry, one last question. I think maybe Mr. Hooper might be the best person to answer this. What's the width of that private drive?
I believe, I have not measured it, but I believe on the TDOT right-of-way plans, it was shown as 18 feet.
Okay, thank you.
And will it be just a one-way drive or intended to be two-way?
The intention would be two-way traffic.
Two-way, and will there be improvements?
There's potential for improvements depending on the outcome of the MMTA.
Okay.
The last note, Mr. Chairman, would be that the church in its current location already utilizes traffic safety officers to manage traffic at income time and outgoing times. Have every intention of doing the same, and certainly if the board needed to place that as a condition on the special exception, you're well within your right to do that, and we would obviously have no problem with that, as we already intend to do so.
Any more questions for the applicant? Okay, thank you
I
very much.
have one,
Oh,
sorry.
wait, we got one more.
Keep coming up with them. Will the facility be used at night? Or do you have more daytime activities or nighttime activities? What?
With any church activity, it's not completely dark and still and empty at night. Occasionally there is the youth group meeting on Thursday night, the volunteer group on Tuesday night. So from time to time, you would have some presence on the property. But as far as the large auditorium and a regular worship schedule, that's obviously going to be the big crowd on Sunday. Other times, much, much smaller crowds, if any.
Okay, thank you all.
Mr. Chairman, just for the record, I wasn't able to stop the time on the school board's clock, so our clock is functioning. It would be just behind you guys, just over to the right here. As a backup, I've got the good old iPhone too, so I'll pair, but I'm sorry, you can't really see it, but I couldn't get it to stop.
Could you give us some kind of countdown?
Yes, sir. You're at 3 minutes and 30 seconds, but I'll give you countdowns
Okay.
at each speaker, or
Sure.
5 minutes, 3 minutes, so that way folks know what they've got left.
That way the opposition can kind of. So,
Yes.
Okay. All
Okay.
right, so we're ready to hear from the opposition.
Yes. So at this time, we'll have members of the opposition, should they like to come forward. Hopefully you guys have talked and kind of worked out your sequence. Does your laptop hook to a standard HDMI? I got no way of displaying it. Yeah. I'm done. I'm sorry. Okay.
We did have a PowerPoint put together, but we're not able to put it up on the screen, so we've got some Chicago background data once one. The members of the board have.
Let's save it.
I think.
Okay. We may actually have, one of the members has a adapter. Let's see if that'll work for us. I don't know which.
Tech savvy that I don't have. I'm not gonna argue with your tech skills.
I'm super tech savvy, and I'll tell my nephews and nieces that I really am. I promise. Can you go ahead and enter it into? Can you go ahead and do it and start the presentation?
I'm sorry.
Can you start the presentation? I mean.
Oh, start.
Yeah. I'm used to it.
Just scroll.
Oh, it doesn't have a forward and back.
Okay, scroll up.
Okay. All All right, Mr. Chairman, we'll now hear from those parties opposed to the case. Again, you in total will have 15 minutes. That time will be right in front of you in just a second. Get the clock reset here. And I'll start it after your initial presentation. Tell us who you are, your street address and such to the board. And Miss, I'll begin with you.
Okay, hello. Thank you for listening to us today. My name is Kristen Walker. This is my husband, Cody Walker, and we live at 4317 Cato Road. So we own the neighboring property that adjoins to 4306 Cato Road. Okay. So many of the points were already done, so we'll go through this as quickly as we can. There are 23 land use districts that a religious institution is permitted by right. There are only 5 that it's not, and they're all the residential districts, which is what this project is in. Okay, we can go down to the church. So this is, we go down to the church. This is the existing church on Cato Road. So we do have a church that sits right next to the elementary school. It's over 100 years old. We had Reverend Rosemary Brown spoke at our community meeting. She's very opposed. She's afraid that her congregation won't be able to get in and out of their church on Sundays due to the size of this new congregation that may come. She's not able to be here today. She's at a funeral out of town, but I told her I would speak on her behalf as well.
The next slide is the Cumberland Elementary School. What's already been kind of spoken about is the traffic that already, I think there's 400 students roughly in that elementary school. And that alone just impedes Cato Road traffic-wise. The one thing I wanted to point out, the people that live up Cato Road are able to use what we call Little Cato Road. It is a little road that connects Cato Road to Eaton's Creek. So if school is letting in or out, we are able to kind of bump over to Eaton's Creek and get around it. But if this proposal went through, basically they would be coming out of Mr. Murray's current driveway, which would block all of us up Cato Road, including 2 subdivisions, from getting out and using that little cut through. So essentially, if anytime they're letting in or out of service, you've got all the residents up Cato Road, including the 2 subdivisions that are almost trapped up there.
And you can go to the next one. So you can see the 2 subdivisions there. That's the road. So you essentially have all these people who are trapped anytime this church is letting in or out.
So that's what we're calling a major safety concern in our minds.
And just for clarification, that's not actually Little Cato. It's actually Cato Road. Cato Road intersects Cato Road. So just like there's a question of Ashland City Highway versus Ashland City Highway, it happens on Cato Road as well. So, when we talk about community benefit, we've already shown you we have a church. We have another church across Ashland City Highway. The majority of this congregation comes from West Nashville, Bellevue. The people pushing this project don't live in the community. They have no stake in this community. They live in Bellevue. We don't have any commercial districts for them to come spend their money. They're going to come, they're going to leave. They don't pay property taxes. There's not going to be any revenue taxes that are going to come to our community that are going to help our schools. At the community meeting, Pastor Ost was asked what benefit what has he done for our community or plans to do? And he asked us to email his mom. Well, I did email his mom, and she said that they have not done any community outreach. They don't currently have any plans to do any community outreach, but, they are open to it.
So let's see, which slide is it? One thing that we wanted to point out, that a lot of the paperwork submitted by Barge and Associates shows an old map aerial view. So it does not show our existing residence. My wife and I just recently built our own personal residence on 13 acres that this sanctuary, if it all goes through, would essentially be looking down on our personal residence that's not shown in any of these maps. So if you go down a few slides, we do show how close our residence. If you see it up there, hold on. So you see the sanctuary proposed right across that fence line is our brand new residence that we built 1,000 foot off the road, mainly for privacy. We certainly wouldn't have built it right there if we would have known some development like this was coming down the pipe.
So we've done some research on the church and their operations. And what we've found is that this church operates more like a festival or a rock concert. A lot of what they do happens outside in the parking lot. They have tents, they have DJs, they have outdoor baptisms, photo ops, they have red carpets, step and repeat, shuttle buses, food trucks. So you can imagine, as a neighbor that lives steps away, and for other neighbors in the area, how this could be a major issue for noise, traffic, safety.
10 minutes remaining.
Yep. So we have a couple of pictures of, we can scroll, keep going. Keep going. So here's the existing traffic on Charlotte Pike, which is arterial boulevard. It's 4-lane. One thing I noticed when I was taking these pictures is many of the congregation actually park in the Kroger parking lot while there are parking spaces available in the church parking lot because they don't want to deal with the traffic.
So one thing, just so that we can kind of hurry ours along so other people get a chance to talk. I guess to me, it doesn't really matter if you want to call this a private drive, this little, what they're calling Ashland City Highway. I mean, I know we're technically saying that it's an arterial boulevard, but when you get down to logistics and common sense, they're still trying to get a 2,000 seat sanctuary in and out of two tiny.
So Mr. Rhett, who helps us with neighborhood issues, he actually received an email from Jafar Ware from Planning, who maintains the county GIS database, I assume for the planning department, on February 16th. He says, as you will see from the left side of the screen under the map layer, local street is categorized with a thin black line. In our database, both 309 Cato Road and 4460 Ashland City Highway are designated as local roads. So you can see his map next, where you see that thin line designating Ashland City Highway there as a local road. So I would say that's a material issue for this project. We've got more pictures of the small road, Mr. Murray's property, no lights. We do have the email with NDOT's. The NDOT does not recommend this project, but this project does not meet the minimum required for approval. There's significant community opposition. Traffic, noise, safety, and scale of this project do not align with the existing community, and the ingress and egress of this project is on two local roads. It is a material issue from a legal standpoint to approve this project with NDOT finding exception of this project, and we are begging you not to approve it.
Hi, my name is Joan Eason, and I live. Okay. Hi, my name is Joan Eason, and I live right on 4448 Ashland City Highway, which is this so-called feeder road. Well, initially, this was not labeled Ashland City Highway. It was called Hydes Ferry Pike. And they stated that there was ability to run two-lane traffic. That's not accurate, because when I come out of my driveway and my neighbor, one of us has to stay in the drive and to allow the other to pass. So it's not a two-lane pass. It's not able to fit two lanes. They also stated that that frontage property was maintained by TDOT. That's not accurate. I've been maintaining that property for 30 years. I've cut it for 30 years, so that's not accurate.
Hello, my name is Nicole Northern, and I live at 405 Spickard Court, which will be one of the neighborhoods of Cato that is basically trapped in our houses if this is approved. One of the problems that we're having, the map that you were shown, the overall map of where the project is outdated. There are now townhouses and single-family houses at the intersection of Ashland City and Cato, and they are clearing the section right next to it, the treed section. They're actually clearing that section out to put in more housing. And then up Ashland City Highway, they're building more townhouses and more single-family houses. We cannot have a light at Cato in Ashland City. We cannot have a light at, it was Eaton's Creek. They told us we couldn't have a light there too, because we were too close to the entrance to Briley Parkway. We won't have a way to get out. It causes a problem when we have an issue. If we have an emergency, we're gonna be trapped. We're not going to be able to get out. It's already a problem when Cumberland is in, but as he said, we can get out by Little Cato. But what the problem is, the people that are trying to go left onto Ashland City from this spot, they're not going to be able to get out. It's a hard time getting out on Cato to go left on Ashland City at any time anyway. So what they're going to do, instead of going that way, they're going to come back up to Cato and block us in even more. So, because that little private drive, it's not viable. And that's part of the reason why nobody has developed on that, because you cannot get out onto Ashland City unless you're going right. And when they finish the townhouses up the street and the townhouses on the property at the end, they're really going to be trapped. There's nothing that we can do to get out if this is built. So, thank you.
Do you, if I could ask, do you have any clue how many townhouses or additional
How many do they have on Cato right now?
I think there's gonna be about 50 total homes that are.
Yeah.
Once the project is completed.
Another 20 to 30.
And another 200 up Cato.
Yeah.
200 straight down the road. You go
Yeah.
next, please.
Thank you.
Thank you. My name is Ian Rett at 4600 Cato Road, Cato Neighbors. I want to point out that the delegating authority of Title 13 requires a positive finding of fact that there is no harm to public welfare. Special exceptions require that it meets the general provisions, and on every case, the ordinance compliance, that is 1715-150B, does not meet it does not comply with the ordinance in that it does not meet the egress standards of the street performance standards of an arterial or two collector streets intersecting. Section C does not meet because the four properties on that bottom line are going to be completely blocked whenever church is in service or getting out of service. There are hundreds of other additional residences up the street that are going to have emergency egress impacted as well. And the absence of traffic controls at the on-ramp of Briley, where this little private road comes out to is actually onto the on-ramp between Ashland City Highway and Briley. So we're going to have traffic control people out there in the middle of State Highway 12, stopping traffic in the middle of an on-ramp, allowing church traffic to come and go, and that seems really unfeasible. Under section
Let me stop. I'm gonna stop your time for you just for a moment. I meant to call out that there's 4 minutes remaining. We're at 3:51 now, but I'll pause and let this gentleman start back.
Thank you so much. Again, pointing out that there's no traffic impact study that was presented here, so you do not have the evidence to create a positive finding of fact that there is no harm. There must be a traffic study in order to demonstrate that there will be no harm to the residents around. And finally, under section I, the hazard protection, there are vigorous outdoor activities that have been pointed out, 94 decibels of sound inside during churches. So on all these basic performance standards, it does not meet. And it must do that. Thank you.
Good afternoon, and thank you for your time. The issue of
Ma'am, if you could state your name and your address, please.
Yes, my apologies. My name is Lydia Kimbrough. It's 2832 Cato Ridge Drive in one of the last developments on up the way. The housing that is currently not pictured there is going to be added. But I would like to go to the picture where it shows this. This is the road that is on Cato. The opposition talked a lot about what's going on Ashland City Highway. The other entrance is right on the road. It's a driveway next to the school. So if you can say honestly that adding emission fuel and exhaust to a residential area with the 4 or 5 houses that are just right there is not a public safety issue, I would be in opposition to that as well. That is completely unacceptable. These people have homesteads. That's a safety issue in itself. The other piece is that we are a family that has been in the lockup that Ms. Joy Kimbrough described on the one day. That is our experience to travel out, to take our kids to a different school every day. We have asked for a crossing guard. Zeal Church won't be able to help with a crossing guard at 8 o'clock in the morning when I need it. I have asked I was told to go to the fire department. I can't even solution regular problems as a resident because I haven't been able to get help. Calling all the right people, but no one is willing. So we have enough issues now that we're trying to work through and struggling to work through. That dump, it's not just an eyesore. It's about our health and safety. And there was a recent lawsuit that was settled to acknowledge, and it was a big settlement to acknowledge the health impact that we already have.
Mr. Chairman, they've got 1:12 for me.
Hi, my name is Travis Kimbrough. I believe.
Can you give us your address, please, sir?
Hi, I'm Travis Kimbrough. I'm also at Edens Creek, Jordan Ridge residence at 2832 Cato Ridge Drive. I believe there has been more than enough information presented to not approve this plan. I would like to speak to you from a father perspective, raising a young family. Right now, the residence as is peaceful and is safe. I remember when this plan was first implemented, there was also a liquor store talked about being added in addition to the church on this land. We have no security of knowing that once this church is built, that there won't be a domino effect where the liquor store is then
30 seconds.
And everything else is built.
Hi, Smith Curry, 4517 Cato Road, the last 20 years. It's about a mile up the street. No matter what kind of legalistic nonsense they say, it does not go onto Highway 12, Ashland City Highway. It does not empty onto an arterial road. It goes onto that tiny thing. And you guys just got to go out there and see. It's so inappropriate to try. I first saw it and I thought it said 200. And I was like, maybe. And then I saw 2,000 seat. What kind of church would force themselves onto a neighborhood and community that doesn't want them at all? I mean, it's bizarre. There's just no way to make it work.
Chairman, time's expired.
Okay, thank you all. How much time does the applicant have left, Mr. Argus?
7:16, sir.
7:16, okay. Mr. Michael, you have 7:16 left.
Yes, sir. This is the owner of the game. The owner or the owner of the Cato Road property is with me here, and if the board wanted to hear from him on the subject, he's here to address any questions you may have, if in fact you have any. And If you decide you have any, of course, he'll be here with me. If not, I'll take a moment to respond to a few of the comments that came up on opposition that merit clarification for the board's benefit. The church's primary operation on Sunday means there is zero overlap or close to zero overlap with the Monday through Friday operation of the Cumberland Elementary School on a nearby property seen in the map here. Nevertheless, we also have to go back down to the legal point with regard to your determination on special exception as to whether or not the method of worship or engagement with its congregation is governed by law. Of course, it is not. Neither in the zoning code, First Amendment protections don't get into that, and the board never gets into that as a result.
Mr. Michael, let me stop you for 1 minute.
Yes, sir.
Mr. Chairman, I made an error in my writing down here. My 716 was, it was, we should be at 3:31 is what I had written under it. So let me adjust his time accordingly. Take a minute. We're going to the
Mr. Michael, while he's adjusting the clock, I did have a question about this. Sure. One of the items that was raised had to do with potential noise. Would the church still be obligated to comply with the noise ordinance?
Still governed by a noise ordinance. The note here that's worth making too is the reason that Zeal wants to make a move from its current location is the parking's too tight, the building's too small. They have grown. Some of their programs take place outside in insignificant part because they can't fit in everybody that they would need to in the building for certain programs. Moving to this larger lot and building a larger facility necessarily gives them a chance to bring those kinds of activities indoors. Thus, number one, mitigating some of the perfectly reasonable concerns that neighbors expressed, taking that off the table. But secondly, yes, we have to abide by the noise regulations that would affect even a residential property, let alone a church, institutional, or other commercial property as well.
Thank you.
One thing that was brought up was the fact
Chairman,
that...
sorry, Mr. Michael. Just restarting clock, Mr. Michael, you've got 2 minutes, 7 seconds remaining.
One point that was brought up that I thought was interesting, and it's not part of the legal analysis, but nevertheless helps make a very practical point, is that a lot of the folks who worship at this church, nay, the majority, don't live in this immediate picture, don't live on this street, live, as many said, closer to the current church location, which is on Charlotte in that area between kind of White Bridge to the east, the Nashville Westmead area to the west. So as a result, if you consider that intersection of Briley and Ashland City Highway shown here, using the point that was made by some of the opponents, the majority of the traffic is coming from the southwest or lower left-hand corner of this picture. If that's the case, based upon what the opponents plainly said, then that means the majority of the traffic leaving the church at this location would be turning right onto Ashland City Highway, left to go south on Briley at that ramp, and leaving this immediate area during the departure time. And on the time when they're arriving from church, if the majority of the people are coming from the southwest, then a majority of them will either be coming straight across on Ashland City Highway or from that southwest on Briley exiting Ashland City. One of the important notes is that because this church has already used for quite some time traffic officers from MMPD, they intend to continue to do so. And if the board were to make conditions on that, that would be fine. If the board were to place conditions that the church kick off one of its ministries by offering to help hire off-duty police officers to help with other traffic scenarios involving the school, which has been presented by neighbors today as a point of concern, I am confident that my clients at church would entertain that. If that's something that would help the community and demonstrate the goodwill, we're more than happy to do something like that. Because throughout the process, our church clients have demonstrated they want to get to this area because it's a good area. They want to become part of the community so that they can serve the community because they're not there yet. Finally, pointing back to a mapping question that was brought forward from a staff level planning department employee in the Mapping GIS division, the answer given in that email is not inaccurate. Some of the documents they have show that. However, the entity that controls is NDOT, and you have their answer.
1 second, I'm going to let him finish his answer. Mr. Mayor, have you completed your answer, Mr. Michael?
Yes. Okay. If there's any other questions, we're happy to answer.
Time is up, Mr. Chairman.
Mr. Michael, I did have a question about you were, I think, trying to scramble to answer it about the arterial street issue that was raised. Can you clarify, there was a statement made during the opposition's presentation that this is not an arterial street. Is that correct or incorrect?
It is correct to say that the private drive is not an arterial street because it's not a public street. This parking lot is not a public street by the same rationale. However, Ashland City Highway is marked in the MCSP, that's Metro Collector Street Plan, or Major and Collector Street Plan, as an arterial boulevard and does meet the description. So the question for the board then to decide is, do I think that private drive is a public street? Or if not, then the first street of frontage is the arterial boulevard, Ashland City Highway. And the only other part that goes with that in concern, as you just asked, kind of implying about the public welfare component of that, the concern of no harm to public welfare should not and legally cannot be confused with no harm to public preference. We understand that the neighbors don't want a church at this location that's a large church. We hear that. But at the same time, the legal standard of no harm to public welfare is not the same as we prefer that it not be there.
But one of the general conditions is the traffic impact, right? And it's not just safety, it's also convenience. That's a word that's used. And that does apply, correct?
It applies, but think about it this way. The question of traffic convenience means no traffic ever, no change ever. We have approved, from what the neighbors are saying, dozens of new residences just to the immediate east of these projects. That's a change in traffic management. More to the northeast from here, I think, there's other residential projects going in. So the change in the amount of traffic in a 168-hour week, I'll invite the board to answer the question. How many hours a week do you think there is a significantly increased traffic flow at this location if the church goes in? Maybe they start worship, early worship at 8 o'clock. Maybe they have a second worship at 11 and Sunday school or Bible school in between at Sunday morning. The notion of traffic and people in houses along Cato and along this small stretch of Ashland City Highway being trapped suggests that just ain't nobody going to let you out in an emergency. That's not been my experience with any church I've ever attended, with any church I've ever lived near, and there have been more than a few, thanks to Daddy being a preacher. It's just not how it's ever gone for me, and I can't imagine that the presence of a traffic officer managing such traffic would literally leave somebody suffering a medical emergency trapped. That's not the case. Worrying about emergency vehicles, that too is they have sirens, they have bright lights, they get wherever they want to go.
No room to get over. Ladies and gentlemen, nothing from the audience, please.
As such, the notion of traffic convenience points to a window of 3 to 4 hours out of a 168-hour week. Just down the hill from where we're hearing, the school is already a greater traffic concern to the neighbors from what they're saying today. This would be a concern if it weren't managed. We propose to manage it. We propose that you put a condition on us requiring us to manage. And if you see fit, help in other ways if we can along the way.
So what kind of condition could we put if we were concerned about, I get what you're saying, which is you're using the math that it's one essentially Sunday a week.
That's right.
What can, because I think the neighbor's concern is that you've got a 2,000 person auditorium.
1,200,
sorry. And I think it's, everybody knows with a lot of larger churches, it's not limited to Sundays anymore. Their events, a lot of them are outside.
And we acknowledge that.
What kind of conditions are feasible to put on, the applicant doesn't want some condition that can only be used on Sunday.
No.
Right. So
But I think
how do we take care of the neighbors and put a condition on it that make sure that they aren't, it's not just Sunday, it's Thursday night and Wednesday night, or there's a...
Well, think about it. It's not so much about the day, but about the crowd. If we've got 50 kids for a youth group meeting on Thursday night, that may not be a big deal. However, if we're having a youth rally like some churches do, and that's taking place on a Saturday, and we are hoping to have 500 or maybe even 1,000 people in attendance, then maybe the board could put a condition that anytime there is an expectation or even possibility that the church will be hosting crowds of X number or greater, and that can be whatever number you see fit, then the church will be required to have traffic officers on hand to manage the traffic. Won't be as much as 1,000 or 1,200 people on a Sunday morning, but will it be better to have them there for 200 people on a Wednesday night meeting about church planning or something, yeah, that'll be very helpful. And we have seen the board place conditions like that, where it's not just about the regularly appointed worship hours or the Sunday morning, as it were, but anytime the number is going to be there, the church will be so obligated.
And the church the burden would be on the church to make a good faith estimate of the number of people that are going to be there?
It would. And in the event that it was determined that they had failed to do so for a number anywhere approaching that, that would leave them subject to a review of the approval that the board has granted.
Thank you. Any more questions for the applicant? Or? Okay, thank you all very much.
We thank you for your consideration. We ask that you approve the special exception, and failing that, approve the variance. Thank you.
Okay.
Members, with that, public, and for the benefit of the audience present watching, the public hearing is now closed, and the board will now deliberate. And the board may, should they wish to question any party that has presented testimony, may do so at this time.
Hey, you opened it up. You got that look on your face.
Yeah, this is hard. I don't know. This is a tough one. I think that to me, the crux issue of it is the extent to which the traffic concern constitutes a public welfare consideration. As far as I can tell, and trying to kind of narrowly focus on what the meat of the argument is, but that's I do think that there's a good argument here that, on the safety of getting into, of ingress and egress into these driveways. But at the same time, I've seen cars backed up and down my street plenty of times. And I don't know how, I don't know how you fix that. I think it's a very valid concern. I'm not sure that concern rises to the level of a harm to public welfare when that could happen across the county at any number of sites.
Okay. So, yeah, I think it's difficult. One of the general conditions is traffic impact, and it's not just safety, it's convenience. And I think we have to give a lot of weight to what the neighbors were saying, because they live there, and the council lady, it's her district, and that concerns me. Also, I don't, I think until it starts happening, nobody's going to know exactly how it's going to work out. And I understand the neighbors' concerns. I'm trying to think, is there a way we can put conditions on this that would make it work? And that's kind of difficult. I think for me, it would have to be some condition that allowed a review at some point if the neighbors, if this didn't address the neighbors' concerns.
I thought the threshold question, I think Mr. Michael did a really good job of giving us two threshold questions, is whether the special exception applies, and then if we found that it didn't, is it there a variance? And I thought it was I found it unusual that NDOT made the recommendation that they did, because normally they don't make recommendations like that. And then I think there's still the question of whether this is, before we get into the meat of what everybody said, if I just drill this down, when I look at that part of Ashland City Highway, and we have the testimony of a neighbor that said it used to be called something else. I think she said Heights Ferry Road, which I'm familiar with. I'm looking at this. I have an email from planning, who also maintains it. I think Mr. Michael did a good job of presenting conflicting evidence, but whether or not this is an arterial road, I have some evidence that says it's a local road. I have some evidence that says it's an arterial road. And I think that's the question we have to decide. Before we get to what everybody else said, I want to know, is this an arterial road? Because it doesn't look like one. As Mr. Michael said, most arterial roads are striped. This is not a striped road. It's 18 feet wide. I mean, I thought it was 18, but it's not even 20 feet. So
So maybe I misunderstood. I thought that they're not saying that that small private road is an arterial road. They're just saying it connects to an arterial road.
Yeah, as I understood it, it was that this private drive, that curved, the thing that sort of snakes in front of the houses and then would theoretically curve around, that is a connection to Ashland City Highway, which is an arterial road, as I
I thought
understood the
Mr.
decision.
Joey in his presentation said, like, it highlighted whether or not this was, Joey, did you put, like, was that in your presentation, or am I making that up?
No, I mentioned that in our initial review of the application, that we believe that stretch to be, because it was labeled Ashland City Highway, that it was part of the arterial. But the testimony you've heard since my initial speech by all parties says, no, that's just a private road.
Yeah, I think that was my question. Like, I think it's debatable whether it's an arterial road. I guess it's from my perspective. Yeah, like, I feel like we had conflicting evidence on whether or not it's an arterial road. So,
The driveway or Ashland City Highway?
so I think before they made Briley Parkway,
Yep.
that was a part of Ashland City Highway. When they made Briley, that little piece, so those people could get to their houses, became sort of like this private driveway, but they still have an address of Ashland City Highway. That's how I understood the evidence, but I could be wrong. I'm happy for somebody to correct me.
You think that's not an arterial road?
It doesn't look like an arterial road. I mean, like Mr. Michael said, for practical purposes, if we look at that street, does it look like any other arterial road in Nashville? So that's, I think for me, like, I think Mr. Michael did a really good job of presenting conflicting evidence, but that didn't resolve the question for me based off of his email from planning and then his email that he had from NDOT, and then based off the presentation and the testimony. I think that's sort of the conflict for me. And I think if we resolve those questions, whether A, it meets that, and then if the special exception applies, and if not, then we could go to the variance question. But I think that's how we can decide this. But that's my perspective, and you guys are way wiser than me, so I'm willing to listen to something else.
You always say that.
Out of ignorance, maybe Joey can answer this question. Having heard these discussions, is this something that the traffic study that's gonna be required as part of this, will that suss some of this out? I mean, I think it seems like, I think to your point too, that not like, there's maybe even conflicting information from NDOT on.
I think there was.
On this, and so,
Sure, no, I understand your question. In the general provisions of section 1716-150, which these are the general things applicable to all special exceptions, letter G under traffic impact states, the applicant shall demonstrate how the proposed use will not adversely affect the safety and convenience of vehicular and pedestrian circulation. The emphasis I want to put on the next sentence, the Board of Zoning Appeals, you guys may require a traffic impact study. It's not a shall, it's a may. So if you felt after testimony that, hey, we need more information to go get a traffic study, you can certainly require it. That being said, I don't know NDOT's process is enough to know that they're going to mandate one as part of the permit sign-on. They have the same power as well to require it or not, but I'd leave that to them. But you do have the authority to require one should you feel it's necessary.
That's why I asked that question. And they said the traffic study's in process.
Okay.
So I don't
They've
personally
engaged the
feel
money.
comfortable approving anything without the traffic study.
Yeah. I agree with that because I think traffic's the big issue here, more than some other issues. So
And
we could
it might also,
defer until we get a traffic study.
it might also allow the applicant to, it seems like there's traffic issues presently that are, that a lot of neighbors have commented on. So perhaps the applicant could get with them and traffic study, it might be able to alleviate some of their current concerns as well, to maybe garner some local support. So. that's
Oh,
kind of up
and
to
also
them.
in the interim, I think it would be since I think Mr. Michael did a really great job offering us conditions, it sounds like we might defer this to allow the completion of the traffic study. Maybe also in the meantime, the applicant and some neighborhood leaders who spoke in opposition can try to craft conditions that would make this more palatable to the neighborhood.
Yeah, I think they're talking and trying to agree on conditions is a good thing for the neighbors because as Mr. Bradford said, it's a hard case. I think it's special exceptions are, if they meet the requirements, it's not like they don't have to show hardship. So, is there
Mr.
a
Chairman,
motion?
did I perceive a motion on the part of my fine fellow commissioner here that we defer this matter for a traffic study? That's what I thought I heard.
I thought it was coming to that for sure.
Well, I'm going to say, can we perceive that that's what it was?
I think Mr. Chairman said it right. I didn't actually make the motion, but if the chairman wants me to, I
Before
will.
we do that, can we open up the public hearing to ask the applicant a question?
Yes.
Mr. Michael, and you don't need to come forward if you don't want to. Do you have any sense of how long it would take you to get a traffic study?
I'd be more comfortable having the traffic engineer answer that question.
Okay,
directly,
that's
Mr. Chairman.
good move.
I'm Beth Ostrowski with KCI Technologies, 500 11th Avenue North. Glad to answer your questions. Good.
How long do you think it would take you to get a traffic study?
So we have reached out to NDOT regarding scoping the traffic study already. I do not believe that that's been finalized. Once it's finalized, it's going to take, the new process is longer than the process used to be, probably 6 weeks. We have spring break next week, so we won't be able to collect data with spring break, right? But about 6 weeks. And then I'm assuming, would you like NDOT to review the study before?
I think we probably would, but I don't want to speak for the rest of the board. I think we probably would.
Yes.
I imagine you would. So
I think getting as much information, since this seems to be the crux of the issue here, it would be helpful. So as much. So yes, is the answer to that, I think.
So yeah, it's probably about 6 weeks to complete the study and then NDOT's review timeframe.
So maybe 8 to 10 weeks.
That feels appropriate.
Which would clearly allow them an opportunity to work with the community.
Right, that should give plenty of time for everybody to continue talking to.
So.
Okay, so we have
close
some
the back up.
parameters for a motion.
You're getting ready to get one. I'll go out with a bang.
What's that?
I'll go out with a bang if you want. Are
Okay,
you going to
sure.
close the public?
Yeah,
So we're back
that's right,
into
we'll
us.
close the public hearing again. So.
I'm going to make a motion that we require a traffic study before this board continues and makes a determination, because there is a knowledge vacuum that without it, and during that period of time, I would obviously encourage the community and the developers to put their heads together with the council person and see what they can come up with. But that's just a suggestion.
Can I make an amendment to that, which is that the traffic study be reviewed by NDOT?
Yeah.
Okay. All right, so there's a motion with an amendment. Is there a second? And do you put a time on when we continue it?
Long after 4 weeks, 12 weeks.
They said they needed 8 to 10. If you want to say, I don't know that they need 12, but.
16. Well, I mean,
Well, they said it sounded like they needed 8 to 10, so.
So they needed 8 to 10 for the study, but NDOT still needs time, right?
First meeting in July. I'm trying to do the math.
that's 4th of July. When's our?
Well, the 8 to 10 was with the NDOT study, so.
Well, they got to review it, and they never.
12 would have given.
12 weeks probably gives everybody.
Okay, so the motion is 12 weeks.
Yep.
Okay, is there a second?
A second.
There's a second. Okay, there's a motion that there be a traffic study that be reviewed by NDOT so they can comment on it. And there's a second. All in favor? Aye. Any opposed? None. Okay, so that passes, none opposed. So that will be put on the docket for.
June 6th, Mr. Chairman, is the first meeting. That would be 12 weeks out, or what you discussed. I'm counting weeks, June 6th. We will require that the applicant notice neighboring property owners again, because it's so far out. We will under our ordinance, forego the installation of a new public hearing sign. You're welcome to alter the sign and put the new date on it. But if you feel necessary to place a new sign, but we will require new written notice and affidavits that those have gone out. June 6th would be, this case deferred till June 6th.
Okay.
As required.
Yeah, we're going to take a 5-minute break before we go to this case, so we'll be back in 5 minutes.
Okay, with that, the board stands in recess.
So that reconnect program is for people who previously enrolled in it.
Wait, you talking about the? There's a bunch of bills on it right here.
We have to go with the Army questionnaires.
Okay, for our folks at Channel 3, go ahead and give you a heads up. We're going to get started again. Ladies and gentlemen, if you'll take your seats, our next case that the board will hear is case 2024-25. Mr. Michael's back with us. This case is Mainland West End Circle. Appellant and owner of the property is located at 3207 West End Circle, requesting a variance from the maximum parking requirements in the UZO, RM40 districts. Just to explain to you guys, we've had one other case prior. So I'm going to give you a little bit of background. The Metro Council, at the end of its last term, before seating this council, made a change to the parking requirements inside the urban zoning overlay. Previously, the UZO had reductions of required parking based upon your use, and you get so much exempted from parking. The council made a change under the zoning code to say that all parking is no longer required for any use in the UZO. However, you're not allowed to exceed the number of spaces. You can't build more than what the code says would have been required of you were you not in the UZO. So a little unusual. But we have had a case like that. If you remember, out in Bellevue is a townhome development. They wanted 2 cars. The zoning code. So that's
Which is exactly what we have in this next case, I believe. Is it?
I think it's yes, sir. I think it's very similar. Let me pull up get the PowerPoint back on track here. So this is the subject property. related here today. It is located within the urban design overlay. You have, I believe, recommendation or a memo from planning regarding the proposal. This is the subject property as it's seen out there today. And then the proposal is to construct this townhome development. We consider this multifamily under the zoning code with a maximum 1.5 stalls per unit. And the applicant is proposing to put in two per unit. So it is similar to, is identical to the prior case, but they're proposing 2 per unit instead of the code's 1.5. So as we talked with the planning department and the council when they passed this ordinance, you may have created an unintended consequence to send people to this board. So I'm going to work with the new council and maybe we tweak this, and hopefully you won't see these in the future. But anyway, with that, I'll turn over to Mr. Michael. Are there any parties present opposed to case 25? Seeing no one opposed, you'll have 5 minutes to present your case.
Members of the board, John Michael, Thompson Burton, 1801 West End Avenue. I'm joined by James Lennon, the COO of Mainland Companies, a friend and a client who is running this project for his company. The short overview is this. It's a small variance, right, that we're talking about 2 instead of 1.5. The project includes 19 units, which means we're hoping to have 38 parking spaces on the lot. For those unfamiliar with the area, this is kind of up above West End. The 31st and Long urban design overlay applies to this area, which is one of the complicating factors in terms of its limitations on height. The townhouse product is the right product to have at this location. The 2-car garage, given that these will be very nice houses, probably not going to be a lot of single folks swinging the price tag on these at the end of the day. And that's a very practical matter that's not part of your analysis, but just calling it like it is. So with 1 or 1.5 parking spaces per lot, we're driving people out to the street to park their cars. And that's already a challenge in this, not just on this street, but in this area. As Mr. Hargis correctly noted.
Does the garage parking count, or is the 1.5 limited to surface parking?
No, sir. It's all garage parking does.
Garage and everything?
Yes, sir.
So you want to have two car, these are 2-car garage?
That's correct.
Okay.
And while my client, Mr. Lennon, will be able to speak to that much more pointedly, I just wanted to touch the overview here. As the basis for the variance is, 1, the dramatic change in slope on the lot. It's approximately 40 feet from one end to the next, which creates certain complications with the way that planning applies the terms of the height restrictions in the urban design overlay. Townhouse is really the only product you get into here. If for some reason the urban design overlay didn't apply here and we were doing something more in the traditional multifamily apartment sense, the density count would go all the way to 48 units. And so 48 units all at once, you say, well, if we can blast and do the parking for that, maybe that's more manageable. But with the townhome product that is essentially begged for under the terms of the UDO, you really do need the 2 spaces. Again, that's a practical matter, less of a legal matter. But the hardship is the unique application of the ordinance, which took effect in December of 22, which, to be fair, I stood up without a client just as a member of the public and supported that ordinance. The eventual inclusion of a maximum with that ordinance has caused some problems for us. And I want to say on behalf of the planning staff, senior planning staff member that I talked with about this, that individual explained to me that it was not an oversight with regard to the way this applies to townhomes, but that they recognize that because the zoning code under the multifamily banner does not differentiate the various housing products, a 10-story condo building, garden-style apartments, or in this case, 19 townhomes, they didn't feel like they could differentiate it in the ordinance and said they always have access to the BZA. The BZA would be able to give relief. That's exactly the relief we're seeking today based upon the unique hardship created by the effect of the ordinance.
Let me ask a quick question,
Yes,
if I could, John Michael. What you're asking us to do in a roundabout, left-handed sort of way, I'm left-handed, is to legislate.
I am asking you to do exactly what the drafters of the legislation intended for you to do, and that is grant a variance on a townhouse product because it's not otherwise defined in the Metro zoning code. And we hope that you'll see fit to do so.
And Mr. Michael, one of the questions I had on this, and I think this was an item that came up the last time we heard this similar kind of case, was the 31st Avenue corridor. Part of the consideration, I think the last time we considered one of these was sort of the nature of the area. This is not a townhome development in sort of the middle of 12 South or Belmont Hillsborough, where you have ample sort of on-street parking, right? This is, I mean, because Long Boulevard and 31st is right near the One City and Parthenon. Okay.
Yeah, the area has historically struggled with adequate parking as more and more small to medium scale multifamily housing developments have come in the past decade. This actually functions as a bit of a, how would you say, a dead end, almost like a cul-de-sac. And folks kind of come ripping and tearing out of some of the restaurants around Margiano's and other places. And who buddy, disappointed to find that dead end when they get there. Meanwhile, the folks who've had to settle for street parking are, hoping to see some of those cars come off the street. Certainly with our development, we want to do our part to keep that the case. And while I'm happy to answer any questions the board members may have, I wanted you to get to hear from my client, Mr. Lennon.
Thank you. My name is James Lennon. I'm with the Mainland Companies.
There we go. Sorry, James Lennon, Mainland Companies. We're at 1905 Ackland Avenue. I made the mistake of sending my talking points to John in advance of the meeting, and he stole them all. So I'm gonna really scale it back again on the question of hardship. Right, this site is. Again, really importantly to note, there's 40 feet of fall. The UDO has a height limit of 40 feet for what we can build. We have property that fronts on 2 streets with no service road. So we did study a multifamily building. Multifamily buildings work really well with shared parking. We studied it. We couldn't make one fit because of the UDO, because of that grade change. If you put that townhome at the bottom left-hand corner of this drawing, the top of that roof is at the dirt level of the townhome on the other side. So if we had tried to create a monolithic building that was ADA compliant, there was really no way to fit a floor plate on it. So we used the site, drove us to the townhome concept, something that could step with the grade. We've got 24 feet of fall going left to right and 40 feet of fall going front to back. So that really is what drove it. So then with those townhomes, we've centered them all around an internal motor court. All the garages face the back. Let me talk about the garages. There was a lot of questions like, are they 2-car garages? Are they not? What are they? The townhome is 20 to 25 feet wide. It's got a 16-foot door. If somebody puts 2 cars in it, that's great. If they put 1 car and they can't line it up right down the middle to fill it with bicycles, that's fine too. We have delivered townhomes in Germantown. We built 18 townhomes. I would, say 4 or 5 of them. Families have chosen to put in fitness equipment. They've chosen, one guy's put in a sauna in their garage. So the garage is deemed to be a 2-car garage by the zoning administrator. It's not striped to be 2 cars. It doesn't have tire stops. I mean, I have a 2-car garage at home. I haven't had 2 cars in it in 8 years. So that's I just want to be clear about it. So it's 20 feet wide with a 16-foot door. It will likely be 2 cars, but it may not be necessarily. And that's where I think it really highlights the issue between when you have a ratio of 1.5 cars per unit is very functional in a garage that is shared. When spaces aren't assigned, you can have turnover. Somebody's out of town. Somebody uses somebody else's spot, first come, first served basis. In a townhome where the garage is attached, it's not like I can, if my neighbor's not using his space, it's not like I can go park in his garage. So really, again, the topography drove us to townhomes. The townhomes drive us to the 2 spaces. That's why we're here.
And if not for the topography, you could have done and intended to do a multifamily that you could have complied, you could have done the 1.5.
Yes, we studied a multifamily. We met with Eric Hammer to kind of see how he would interpret how the topography worked with the building setback. And it really just became evident that a monolithic building didn't work on the hill.
So just to clarify the request is for 2 spaces per unit, and the requirement is 1.5 spaces per unit.
Correct.
So I think all the opposition letters, like many of us, misunderstood what you're asking. And so a lot of the opposition was thinking that you were going to provide less than what was allowed, but you want to provide more than what was allowed.
That's correct.
So I think that's important to clarify because we have a lot of opposition letters.
And I don't think the opposition also understood that these were going to be in garages from reading some of them. I don't think they understood that either.
And Ms. Carpenter, we actually had a couple of calls along those lines. As you brought up the point, there was a lady here earlier today that once she talked to us and understood what the request was, she was delighted and offered to stay and speak, and I think may have been dissuaded by the length of the prior case. Apologies for that. I certainly understand. However, I think, our notice letters that we send out from the BZA are very general, as you guys have seen in the packets. And I don't say that critically. You don't want to sit there and expound with a 10-page memorandum on every single thing. But it does just say parking variance. And in the future, and there will be a future because we have other projects already in the pipeline that will come to the board for this similar type of request, we will make it a point to work with staff to make it abundantly clear that this is a request for variance from the parking maximums and asking to add a little bit more.
And is this a true 2 spaces per townhome? It sounds like it's technically a 2-car garage, but you can't fit 2 cars in it.
You can fit 2 cars in the garage. Yes, it is designed to be a 2-car garage.
Okay.
How wide are the units?
The units, the narrow ones are 20 feet. The wider ones are 25.
Okay.
Again, all the garages enter off that internal motor court. And,
So
I
it's
mean,
tight.
it's tight, but it's almost as if most of these letters of opposition are actually a letter of support because they must talk about how there's not enough parking.
Yeah,
Exactly.
it's the best supporting documentation Mr. Michael's ever had from neighbors, I think.
right.
I think all those letters also kind of establish that a unique characteristic of the property may be that it's surrounded by other properties that they don't have adequate on-street parking, because that was one thing the neighbors, when they didn't understand what was going on, that was one thing they talked about.
And I actually know that area really well because my office is right there. Literally a half block from that space, so I know it really well. It's super dense.
We should close the public meeting, I guess.
Sorry.
But no,
Do you have some more time left?
About 15 seconds.
15 seconds, okay.
You can't say his name in 15 seconds.
Any more questions?
I'd like to thank Mr. Lawless for his years of service to this board. We appreciate you, Mr. Lawless.
We all thank you for that, Tom. Okay, we'll close the public hearing and
I cut my hair even shorter and more bald today just to honor Mr. Lawless. So, that was for
I
you.
wanted to make sure on this one that I share your thoughts exactly, which this 1.5, you sure wish they would have thought about carving something out for townhomes. But I do believe that the applicant has made a sincere effort to try to do something that could comply with the 1.5, and the topography didn't work. So, and I do think also that there is a unique circumstance here that we heard from the neighbors, which is there's a real concern about there being adequate parking because of the configuration of the neighboring property. So,
And that was, I think, the main consideration the last time we heard one of these is that essentially this is, we're not building a row of townhomes that's in on a major street in Belmont Hillsborough or something where everybody has street parking and 1.5, it might be warranted to not necessarily exceed that maximum. But here it's it's a development next to another development in a almost quasi-commercial area at times too. And so, I think that, the safety
I'm trying to articulate the hardship.
Well, no, I
as
think
well as I can,
that
because
the nature of it, I think
Mr. Lawless is,
it's a safety driven.
he made a very, very valid point about that.
I'm having a hard time getting over that. Can we open the public meeting for just for
I
about
don't
2 or
think
3
anybody objects to
questions?
this. No. Okay.
Because now I'm grabbing, because I'm also looking at legal counsel over there, and I'm a strict constructionist type of person. But do you have a line that delineates that they're actually 2 parking places or just an open area?
It is an open area. There are no striping and no tire stops.
And for the record, the code in dealing with these types of parking spaces don't require the striping. We look at an 8.5-foot width times 2 is 2 cars, 17 feet.
It's a 16-foot door.
So,
As such, Mr. Lawless, we've
Really,
constructed
really
the law.
wider than that.
oh, actually, look, I take that back. We are residential parking, so we're 8 foot wide by 18, deep. So,
And in an effort to be strictly constructionist with the terms of the zoning code, Mr. Lawless, we've gone with what Mr. Hargis told us.
Oh, well, I'm trying to find a way for the first time in my 5 years, John Michael, so.
Planning recommended it too.
I know, I'm just, but we're going with the normal standard, right, Joey? Okay.
Any,
I'm in support of it. I think there's
Yeah.
a variance. I'm just putting that out there in case that helps people.
No, I think there's, I mean, I do think that there is a way to distinguish this type of townhome development from a different type of townhome development so that it's not just that there are circumstances, I think, to the way that this thing is cited. So instead of just saying we're getting to yes, I think they have a very legitimate case based upon the nature of the surrounding property, so.
And most of
The nature of the land.
Right.
The land sort of led this type of development.
I will share that I have a 16-foot wide garage. I also have a 2.5-year-old, which means that my 16-foot wide garage is a 1-car garage.
Open the door to get in.
Yeah. A stroller.
It's worth planning,
I'll make a
also
motion
support of it.
that we approve the application based on the hardship being the topography of the lot and the unique characteristic being the surrounding surrounding properties, the way they're configured. There appears, according to a lot of letters from neighbors, to already be inadequate parking. And based on those two things, I'll make a motion that we approve it.
I'll second.
All right, there's a motion, and a second. All in favor? Any opposed?
So that I can at least make one claim for Mr. John Michael, I would like to abstain.
Okay. So there's 6 in favor, 1 abstention. Is that, did I count? Okay, I think I counted. Okay, thank you, gentlemen. Next case.
Thank you.
our next and final case of today's agenda is case 2024-30, West Nashville Residences, is the appellant owner of the property located at 140 Hillside Cottage Lane, requesting a variance in the setback requirements in an SP district. Now, this is for a ground sign. The applicant seeking to construct a monument sign closer than the zoning code requires. Zoning code requires a 15-foot setback, and I'll let the applicant cover on what they're doing. But the subject property, apologize. These are the townhomes which are being constructed on this site. It is an SP. The planning department has approved this SP plan with setbacks of the buildings themselves less than 15 feet. And so the applicant's requesting to have a monument sign be placed out there so for visibility purposes. There's not much to see in the way of ground shots. It is under construction. We couldn't get too deep into the site, but some views along the road. And then the proposed monument sign location proposing to be at closest length 2.18 feet from the new right-of-way. And this is the ground sign proposed height. And the planning department has recommended approval with the condition that NDOT shall ensure the site distance for vehicles is not impeded by the height of the sign. And we'll put them on the permit itself. So with that, I'll turn it over to you. Are there any parties opposed? No. So 5 minutes.
Good afternoon, Board. Andrew Wiseman, Callis Design Group, 5100 Tennessee Avenue. This case here, we previously made the mistake of not including the monument sign within our preliminary and final SP plan. You'll see in some of the documents, if you can flip over to the site plan that we sent that shows the overall view, it'll be a little bit easier to explain that right there work. And as part of our application, I hope y'all have this in y'all packet, but we also provided a site schematic that shows a NES transformer just directly southwest of that unit 140. That is where we would intend for this sign to go in placement and replace the NES transformer. Just for the simple fact that if we have to comply with a 15-foot minimum setback of the sign, it would be tucked back into the property and it would not be visible. It would be useless signage for wayfaring. So you can see the adjacent neighbors, they have townhomes that are within 15 feet. So as you approach our property, as we were constrained by both the dedicated right-of-ways that we were given with this property, as you approach us, you're seeing a wall of townhomes and would not have any kind of instructive dedication to know that you're approaching our site. So our ask is simple, is that we would like to pull that a little closer to the streetscape, work with NES to try to relocate the transformer and hopefully in its place put this monument sign so that we can have proper wayfaring. And I'm open to any questions, and I don't know if I can reserve time if you need to. But I feel like this is a straightforward request and like to hear your feedback.
Any questions for that?
So you've already entered into discussions with NES on
Yes, sir.
relocation and all that.
So we've discussed it with them, and we are working on our revised Exhibit B to accommodate the monument sign.
And you have no issue with the condition that planning has submitted of ensuring that it doesn't?
Impede, yes. So we have on-street parking along the entire Hillside Cottage Way there. So the site distance triangle isn't going to be much, and there was an NES transformer sitting there today. So, so we don't think that NDOT's going to have an issue with it, but we will be subject to that. And if nothing else, it would go on the opposite side of our entry drive. Still, the request is to put it within 3.5 feet of the back of sidewalk, I think. So you said 2.1, but that was the transformer that's the transformer as it exists today. So we're just looking to get it 3.5 feet.
Thank you.
Any further questions? Okay, we'll close the public hearing. And let me just start off by saying, I would have recommended this for consent, but because it had the condition on it, you can't really do that. So, let me just throw that out there.
Yeah, I mean, to me, that's sort of the number one consideration on these is does the sign, is there going to be a visibility issue with traffic? And I mean, I think that's, applicant doesn't have an issue with the condition. So, I mean, I'd make a motion that we approve the variance as requested with the condition requested by codes, or by planning, excuse me.
Second.
I'll second that.
Mr. That's his parting shot here.
Parting
Okay, that's
shot,
right.
yeah. Make it easy.
All right. Any further discussion? Okay, all in favor? Any opposed? Okay, that passes. Mr. Wallace, is this your last meeting?
Yeah.
Okay, well.
You are able to serve one more 60 days.
Okay.
You're not going to call me unless I'm sure.
Sure. Yes.
Well, I wanted to make sure we thanked you. This is going to be your last.
I would like Mr. Lawless to come wearing like a Hawaiian retiree shirt, maybe a tracksuit,
Sandals, flip-flops.
Can I bring my mango daiquiri?
Yes. Yeah. The South Florida parrot head,
No, I didn't sit on the spot.
That's a zoning question. I can't. I'll defer to Jerry on that.
What's that question? Sorry. Yes. You're on. You're on.
Motion. Look at that second. Okay.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.